All right, thank you, ladies and gentlemen, for your patience. Let us resume where we were. I'd like to go ahead and announce my ruling on the various motions. I think defendant's filing number 59, which was a motion to strike the aggravating factor of heinous, atrocious, or cruel, was reserved by the court to determine after the guilt or innocence phase of this trial, but before sentencing, and that's the way I will handle that particular situation. Number 63, which is, again, having to do with the prior violent felony. I need more time, and since I don't want to keep everyone waiting for me to be able to review all of this information that's been submitted, I intend to deal with that particular motion by written order issued within the next 7 to 10 days. I will not delay it, but I wanted to have just a little bit more time than I have today to look through that. Number 61, defense filing 61, which is essentially the defense's motion for a outline of the state's case at sentencing. Court finds that what the defendant wants is an outline of the state's evidence at sentencing, and that the state has contended that they have provided all of the evidence that will be introduced in their discovery and do not wish to have to do anything further than that. What the defendant really wants, in my opinion, is this outline of the state's strategy for the sentencing hearing, and I don't believe that that is required under the laws of the state of Tennessee or the rules of procedure that we are following. However, I do find that there is a necessity that the state should give a witness list of potential witnesses that will appear at the sentencing hearing. I think that is something that would be required, and that would be including any victim impact witnesses that might be intended to be called at that sentencing hearing. Also, under Rule 12D, subsection 2 of the Rules of Criminal Procedure, I think the state would be required to give notice of their intent to use evidence, but it would not be required that they would have to outline how they intend to present their case as the defendant was requesting. So I think there's a distinction between Rule 12D, subsection 2, notice of intent to use evidence at a sentencing hearing versus an outline, so to speak, that gives the strategy that the state intends to employ. Having dealt with all of those, then I move to the motion for interlocutory appeal and stay. This court has to make a lot of decisions on a day-in, day-out basis, and none of my decisions are any more important than the decisions that I make in this case, because of the ultimate penalty that the state is seeking is the death penalty. The court has considered very carefully the motion that the defense filed for me to set forth the Reed strategy or the Reed procedures for an evaluation of the defendant by the state's expert. I've also carefully evaluated their motion for an interlocutory and appeal and a stay of my ruling on how that is to be handled. For the record, so that in the event there is an appeal, this court wants to make sure that it's clear on the record what my ruling is and how I've arrived at that ruling. I've read the Reed language very carefully. The Reed language is pretty clear cut about the procedures to be followed. And not to belabor the information that's already been presented, but essentially says that if a capital defendant files a notice that he or she intends to introduce expert mental condition testimony at the sentencing hearing, which we have in this case, the defendant shall, if requested by the state, be examined by a psychiatrist or other mental health professional selected by the state, and that has been requested by the state. The examination shall take place within a reasonable time frame set forth by the trial court, and I have tried to do that in a way that it would be completed prior to the expected trial date in this case. Here is the difficult part. The state and the defense will cooperate to provide the court-ordered professional with all necessary and relevant information. Said examination may be videotaped in accordance with the guidelines adopted in State v. Martin. The report of that examination and the report of any psychiatric examination initiated by the defendant shall be filed under seal with the court before the commencement of jury selection. So it clearly is identifying that this examination and the examination by the defendant's expert will be completed prior to the jury selection, which is, as of now, July 26th. Court-appointed professional conducting the examination for the state shall not discuss his or her examination with anyone unless and until the results of the examination are released by the court to counsel for the state following the guilt phase of the trial. And it goes on to released to the defense prior to trial. So the defense is going to have this information before the trial ever commences to enable the defendant, with the assistance of counsel, to determine whether or not to introduce expert mental condition testimony as mitigation at a sentencing hearing. The results of any examination shall be released to the state only in the event the jury returns a verdict of guilty of first-degree murder, and only after the capital defendant confirms his or her intent to offer expert mental condition evidence in the mitigation at the penalty phase. After the return of the guilty verdict, the defendant shall file a pleading confirming or disavowing his or her intent to introduce expert mental condition testimony at a penalty phase. If the defendant withdraws his previously tendered notice, the results of any mental condition examinations concerning the defendant will not be released to the state. The reports of any examinations, whether by the state or defense experts, concerning the defendant shall be released to the state immediately after the filing of the pleading confirming the earlier notice, even if the defendant confirms his or her intent to offer mental condition evidence. The defendant may withdraw the notice of intent to introduce the expert mental condition proof at any time before actually presenting such evidence, and in that event, neither the fact of notice nor the results or reports of any mental examination, nor any facts disclosed only therein, will be admissible against the defendant. That is the Supreme Court's of this state's procedure to be followed in a case such as this, in a death penalty case. And the defendant has filed a notice of intent, and their contention is that the only thing they're required to do is to give notice of the qualifications of the name and what the field is and what they're going to be testifying to, and then it's up to the state to have their expert do an examination. But I want to go through what the defense has filed in this and compare that to what the state, or what the Supreme Court rather, says in the Reed case regarding the cooperation of supplying information. First witness they identify is Dr. Dale Watson, a PhD. His professional qualifications are a neuropsychologist. The topics to be addressed is Mr. Wiggins' neuropsychological functioning profile as revealed by neuropsychological testing and the neuropsychological effects of chronic exposure to childhood trauma. How would a state expert be entitled to rebut, and that's what they are, they're rebutting what the defense expert is called to testify about. How can a state expert rebut the testimony of an expert who is relying upon neuropsychological testing and the effects of chronic exposure to childhood trauma unless that expert is supplied with that same information? I don't think they can do that. A second witness is Dr. Melissa Caron, MD. Professional qualifications are a neurologist and epileptologist dealing with epilepsy. Her topics to be discussed are seizure disorders and a neurological examination of Mr. Wiggins. Theoretically, the state's expert could do their own neurological examination of Mr. Wiggins if they so chose. The third witness is Dr. Bhushan Agarkar, MD, professional qualifications as a psychiatrist. Topics to be discussed: Mr. Wiggins' psychiatric functioning and the psychological and neurobiological effects of chronic exposure to childhood abuse and neglect. How can the state's expert be expected to rebut any evidence or opinion based upon exposure to childhood abuse and neglect unless and until they are given the same information that the defense expert is given regarding such alleged childhood abuse and neglect? Dr. Aaron Bigler, PhD, professional qualifications, a neuropsychologist and expert in neuroimaging. Topics to be discussed: electroencephalogram of Mr. Wiggins' brain, a structural MRI scan of Mr. Wiggins' brain. Again, unless the state's expert is allowed to conduct the same type of test, they would necessarily have to have access to those results in order to make an evaluation. That would seem to me to be necessary and reasonable information. Dr. Andrew Newberg, MD, qualifications as a neuroscientist, topics to be discussed, the PET scan of Mr. Wiggins' brain. How can the state's expert review or rebut that and make a determination unless they either perform another PET scan or they have access to the results of that exam to make a determination? Lastly, Dr. Bradley Freeman, MD, of professional qualifications as a psychiatrist. Topics to be discussed, Mr. Wiggins' psychiatric functioning and the lasting effects of chronic exposure to childhood trauma and the adverse effects of adverse childhood experiences. And again, simply stating that in a notice does not give the state's expert the necessary and reasonable information that would allow them to conduct this a testing of their own or make their own evaluation. And that's the reason that I find that under the Reed case, the language in Reed is very clear that both parties are to cooperate with providing the necessary information, and it is done in a way that provides that once that information is provided and the state's expert makes their own evaluation of Mr. Wiggins's issues as identified in the state's notice or in the defense's notice, his report would have to necessarily be filed with the court before trial, and that of the defense expert would be filed with the trial under seal, and that would be done before trial. And as a result of that, the state would never be able to see that until they get to the sentencing hearing. And then only if the defense does contend and does use their own psychological evidence of mental health issues would the state be entitled to see either one of those reports. It is the Supreme Court's method by which they protect the rights of the defendant, and by the way, they, in the Reed case, make it clear that the defendant submitting to such an examination by a state witness is not violative of his Fifth or Sixth Amendment rights, and in fact, it only has to do with the ability of the state's expert to adequately evaluate the defendant. So, for those reasons, the court has found that the defense expert should be required to provide the same information to the state's expert that it relied upon in determining or arriving at its decision or opinion, and that information was necessary and reasonable. Otherwise, the state would have to conduct a wholesale examination of Mr. Wiggins just based on those loose and very broad areas that are identified in the defendant's notice, which I believe would possibly subject the defendant to a far greater invasion of his rights than what we are talking about with requiring the defense expert to provide. This is, again, just limiting the state's expert witness to only those items of information that the defense expert relies upon to arrive at his discussion, at his opinion. But when you have an expert that's going to testify about childhood trauma that they claim imposed some sort of psychological effect on Mr. Wiggins, then clearly the state's expert is entitled to know what that alleged childhood trauma is in order to form their own opinions. I don't know how that could be anything but necessary and reasonable, and it requires the cooperation of both the state and the defense to obtain that. I think that the Reed safeguards, as outlined by our Supreme Court, have made it very clear that the information will be protected and so forth. The question becomes as to whether or not there would be a report filed, and I would simply point out that instructive to the parties is the State versus Harold Wayne Nichols, a Supreme Court of the State of Tennessee case from back in 1994. And at that hearing, the defense had an expert psychiatrist who didn't prepare a report, and instead, until the second day of the trial, and when they prepared a report on the second day of the trial, the defense attempted to prevent the state from having access to notes and so forth that he used to testify. And in that case, the Supreme Court upheld the right of the state, where no report was filed, to obtain the notes of the psychiatrist and use those notes in cross-examining him. The trial court allowed it, and of course, I think that was under a Rule 16, Rules of Procedure, Criminal Procedure for the discovery of relevant information. But I just make that apparent that there's obviously a basis for this court to order that in the event there is no report, that it may be necessary to go further and require that there be notes or other what is prepared by the expert to testify. Maybe have to deal with that at the sentencing hearing, but there is some basis for that in the law. That case is, although, by the way, 877 Southwest 2nd, 722, Tennessee, 1994. Now, as to the essential element of what we're dealing with on this motion is a request for the Rule 9 interlocutory appeal. Rule 9 of the Rules of Criminal Procedure provides that a permission by the trial court to appeal can be granted on an issue on an interlocutory or temporary basis while the case is still pending in this court. It goes on to state, in determining whether to grant the permission to appeal the following while neither controlling or fully measuring the court's discretion, indicate the character of the reasons it will be considered, because if I were to grant it, the appellate court can still refuse it. In any event, the first factor is the need to prevent irreparable injury, giving consideration to the severity of the potential injury, the probability of its occurrence, and the probability that review upon entry of final judgment will be ineffective. This court finds that that does not apply in this case because there is no irreparable injury by my ruling on this. I believe my ruling to be legally correct in keeping with the Reed judgment. No case has been cited to me to contrary to what I have ruled in this case, and the probability of review upon a final judgment being ineffective is not, in my opinion, very great. I think if I am incorrect in my ruling, then I think that the final appeal, if that results from a judgment in this case, that the appeal would be necessarily able to resolve and correct any error that I have, and therefore I do not find that the first factor applies. The second factor is the need to prevent needless, expensive, and protracted litigation, giving consideration of whether the challenged order would be a basis for reversal upon entry of a final judgment, the probability of reversal, and whether an interlocutory appeal will result in a net reduction in the duration and expense of the litigation if the challenged order is reversed. I do not find that to be applicable either. This case has been pending for 3 years. It has been continued on at least a couple of occasions, I think, on the defense's motion. This court has bent over backwards to try to accommodate the needs of the defense in preparing their defense and allowing them to get the type of testing done that they sought. The court has attempted to accommodate every request, and in addition to that, there's been a delay due to the COVID-19 pandemic that has caused all of our jury trials to be suspended. This case has been pending long enough. It needs to be tried, and I believe that granting an interlocutory appeal would unnecessarily delay the entry of a final judgment, and I don't believe that it would affect the probability of the final judgment being reversed. And I think that it would result in an increase in the duration and expense of the litigation if I granted an interlocutory appeal rather than denying it. Last factor is the need to develop a uniform body of law, giving consideration to the existence of inconsistent orders of other courts and whether the question presented by the challenge court will not otherwise be reviewable upon entry of a final judgment. Again, this court finds that there is no inconsistency in the law, and I understand Mr. Evans is a very eloquent lawyer and he's done a very good job of arguing his position, but this court's position is that there is no case law that's been cited to me to indicate that I am incorrect in my interpretation of the Reed procedures and what is required as necessary and reasonable for the information to be provided. It is correct that if this case were to go up on appeal, that there would be a basis for an appellate court to make an interpretation more so of what, but the argument could be made that our Supreme Court intentionally left the language in Reed to be somewhat generic and non-specific to allow for each case to be decided by the trial court on the basis of what the facts were and so forth, rather than to set forth an attempted set of specific rules about what type of evidence can be admitted. No two capital cases are the same. No two cases necessarily have the same type of mental health evaluations that are going to be performed. But it is this court's opinion, at least, that the Supreme Court could have, as Mr. Evans correctly points out, set out specific guidelines to give us instruction on what we can or cannot allow or require rather of the defense to give information to the state. I believe that common sense dictates that the information I am requiring the defendant to show will provide both sides with the same type of standing for their expert witnesses to testify at a sentencing hearing, and that to do otherwise would allow the defense witnesses to have all of this information upon which they can base their opinion, and then the state's evidence or the state's expert witness would not be allowed to have that same information. It would be subject to cross-examination as to the weight to be given to their testimony. Both sides need to have an opportunity. I think that's what Reed is all about, giving the state an opportunity to present its own evidence at a sentencing hearing. This is not the guilt or innocence phase. And based upon all of those things, it is this court's opinion that this court ruling is reviewable on a final appeal, and any error that I may hopefully have not made, but if I were to have made an error, that it can be addressed in a final appeal, and therefore an interlocutory appeal. And moreover, a stay of these proceedings is inappropriate, and the court denies and declines to grant that motion. I would also observe that there is a procedure whereby the defendant can seek an emergency interlocutory appeal under Rule 10 of the Rules of Appellate Procedure, and that the appellate court could, if they find that I have so far deviated from the norms that they need to address that issue, then that's available to the defendant as well. But this court's opinion that an interlocutory appeal under Rule 9 should be denied. That concludes all of the matters that we have before us today, but before counsel is dispersed, I would like to meet with you in chamber or back in the conference room so that we can go over some scheduling issues about the beginning of the trial. Is there anything else that I have not addressed other than these things? All right. Then we will stand in adjournment, and we will come back to the conference room, and I will discuss the other issues that we have. Thank you.
All rise. This court is adjourned.
Hey, Jennifer.
Yeah. He'll have to have that back so he can do the written rule.
Doesn't need me back there, does it?
And Pam Billingsley, you can go ahead and holler at me now, but I forgot to push record this morning, but